But Judge,
he keeps saying he doesn't have to.
Right.
Counsel, just because you say it doesn't make it true. What he does, what you're arguing to the court is that the officer, upon some assessment, can take some preemptive strike because he believes that something is going to happen that hasn't yet happened. Well, I'd like to see even the law that gets me there.
Their policies and procedures provide for that. They can use the level of force that they believe is necessary. It's left to the employee's discretion. And it's enumerated in there. There's active resistance, passive resistance. If an individual is combative physically, or if they're just refusing to comply. Now, in this case, you're saying that he should have said, hey.
Welcome back to Court Reacts. This one's a little different because the man in the hot seat is wearing a badge. A sheriff sergeant got charged with 2 felonies after he pepper sprayed a woman who was handcuffed in the back of a locked patrol car at the county jail. And the judge on this case is one you might recognize from this channel. Judge Cedric Simpson out of Washtenaw County, Michigan. Today, he's not sentencing a defendant. He's deciding whether the state has enough to send a cop to trial. Watch how carefully he works through it. Nothing here is decided yet. This is a preliminary exam, so everybody's still presumed innocent. Let's get into it.
Yes, sir.
And are there policies regarding that?
Yes.
What is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision or anytime there's a policy that's newly published and sent out in a program called Power DMS, the employees are required to review the policy and electronically sign. And yearly, there's also a restraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and take a test.
Okay.
Successfully pass the test.
Specific to ASR?
Yes, sir.
Okay. What is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used any time that the person that's applying force feels that lower forms of control will not be adequate.
Okay. You said something about the individual not being a threat.
Yes.
Where does that fit in?
ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle, bars out the window, it was difficult for me to see whether or not there was a threat to anybody else.
Okay. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevance. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Cards.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think as it's phrased, I think it's.
Thank you. In a situation like this, Commander Shipakasi, where someone is handcuffed and in the back of a vehicle, is that based on both your understanding of the policies and your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no.
Okay. And why is that?
Because the person was not a threat at the time of ASR.
So that's the prosecution's own use of force, Commander. And he's not mincing words. ASR, that's the chemical spray, basically mace, is supposed to come out when someone's a threat. And his read is she was handcuffed in the back of a caged car going nowhere. Based on his training and experience, not a situation where you spray. Now, to be fair, that's his opinion on the record. A jury would still weigh it. But when your own department's commander says it shouldn't have happened, that's a hard place for the defense to start.
No threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No.
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
No, because she was in the back of
Okay.
the vehicle.
Is that where she was going to be housed?
No.
Okay, so what do the officers have to do to house her?
Move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, it's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. Is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay. So did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car?
When she was on the way there, yes.
She was screaming, yelling, insultive, combative?
Yes, sir.
Okay. The officers have to make a determination to get her out of that car, right? How they're going to do it?
Yes, sir.
Now, the 3 questions were just a precursor to getting her out of the car, correct?
Yes,
The officers were actually there to extricate her from the car and put her in a cell.
yes.
Okay. Sergeant D or Day and one other person, what was the other sergeant that was present? Do you recall?
Police Sergeant Mary.
They're the ones that are in charge of getting this individual out of the car, right?
Yes.
And again, the ASR doesn't appear on the chart because you said that, I want to get this quote right, not part of the continuum because it can be used anytime the officer feels or believes. And what was the rest?
Forms of control, not the act.
And here comes the defense doing exactly what a good defense lawyer does, chipping at the word threat. Her feet weren't restrained. She was kicking the car on the way in, screaming, combative. The point he's building. Officers still had to get her out somehow, and maybe a kick was coming. Hold on to that, because the judge is going to test exactly that idea later. The difference between something that's happening and something you think might happen.
You just cracked the window. Hey, Rachel. Hey, my name's Sergeant D. I'm the supervisor that's on shift right now, along with Sergeant Merritt. Okay. Hey, so I want to get you in, but I want to work with you. I don't want to. I do. I want to work with you. So I get paid whether you're here or not. I want to get you in the door. And we are having a conversation right now. No, we're not going that way. Are you? I'm asking questions. Are you? I have been treating you. So, are you? Yes, I'm going to treat you with respect. Are you? Yes or no? My question. Do you have any emergency medical needs? Yes or no? I have been. Rachel, I'm trying to help you out. Answer yes or no. So here's what I'm going to tell you. Still not answering the question. I'm trying to get you taken care of, and I'm trying to work with you. I'm asking you, are you going to treat me with respect? Do you have any meaning? I've already told you yes. Yes. This is the last time I'm telling you. Right now. Yes.
That's the body camera the parties agreed to admit. And listen to what's actually on it. He's asking her questions. She's not answering. And then, this is the last time I'm telling you. And the spray comes out. I want to be careful here. I'm describing what the footage shows. I'm not the one deciding what it means. But the thing the next witness keys on is, what command did she actually refuse? He asked questions. Asking a question isn't the same as giving an order.
Okay. What do you mean problematic?
The use of ASR is for someone that's non-compliant. You've given them a directive, told them something specifically to do, afford them a reasonable period of time to comply with that. Okay. And you also give them a warning that if they don't comply with that there will be consequences, and subsequent to that, the ASR will be deployed. What I saw here was none of that took place. There was no warning given. There was no directive given. In terms of a threat, Sergeant D or anyone else, she was confined in the back seat of a patrol car, handcuffed behind her back, in a particular patrol car that has cages all the way around. She did not exhibit any aggressive, threatening behaviors that would necessitate the use of ASR, nor was a warning given to her. So when we talk about ASR, what we're talking about is you want to gain compliance. Okay. Well, you have to have a directive to gain compliance. Okay. Asking questions is not the same as giving a directive as I want you to do this. We are getting ready to open the door. I want you to step out of the vehicle. Okay. None of that was given.
Okay. Tell me a bit about ASR itself, and you talked about when it is appropriate to to use, but what is the effect of it?
It's basically a combination of like CS gas, agent, a chemical agent that creates an irritant, so it momentarily incapacitates a person.
Pain, right? It causes pain.
Absolutely.
And that's the whole case in one breath. The investigator lays out the steps the policy requires before you ever deploy the spray, a directive, a reasonable chance to comply, and a warning that consequences are coming. His testimony is that none of that happened. No order, no warning, and a woman locked in a cage who, in his words, didn't show the kind of aggression that would justify it. He also points out the spray causes, his word, absolute pain. So now the question stops being, was she annoying, and becomes, did he follow the rules that exist precisely for moments like this?
Necessary for bind over, and I ask that you do so.
All right, just one question.
Yes, Your Honor.
Say the door had been open, either side, doesn't matter. And the arrestee is now out of the vehicle and let's say is thrashing around. We wouldn't be here, I guess.
I'm not sure
And then the deployment of the ASR.
I'm not sure that's I mean, in your hypothetical, she is still handcuffed. She is still a restrained person and within the jail. Kicking and thrashing around, I think that that there might be an argument that the use of ASR or other force is necessary, but in this circumstance, there's 7 officers around that car. Someone kicking and thrashing around happens often, and they are not sprayed while they are restrained.
Now watch the judge. This is what a fair judge does. He doesn't just take the prosecution's side and run. He pressure tests them too. What if the door's open and she's thrashing around? And the prosecutor's answer is the line that lands. There were 7 officers around that car. People kick and thrash in a jail all the time. And you don't spray someone who's already restrained. He's poking both sides. That's the job.
What was he gaining compliance to?
To get her out of the car. That was it. He wanted to get her out of the car in a manner in which she didn't fight with the officers and the officers weren't hurt. And it was successful.
As I look at it, how would I know she wasn't going to comply with that?
You wouldn't. But if the officers take her out and they're injured, then you're second guessing saying, why didn't you use the pepper spray to get her out? Because that's why you have it to distract her.
No. But I would
Judge,
be
I
second
haven't-
guessing. Would I?
Yes, because that's why we're second guessing now.
No, I don't think we're second guessing. I mean, the issue becomes, he didn't ask her to get out of the vehicle.
He doesn't have to.
All right. He doesn't say, we're going to take you out of the vehicle.
But
He keeps
Judge,
saying he doesn't have to.
right.
Counsel, just because you say it doesn't make it true. What he does, what you're arguing to the court is that the officer, upon some assessment, can take some preemptive strike because he believes that something is going to.
And here's the heart of it. The defense keeps saying the spray was about gaining compliance. And Simpson asked the obvious question nobody answered. Compliance with what? He never told her to get out of the car. The lawyer's answer is he doesn't have to. Once, twice. And the judge is sitting there watching a guy charged with a felony where the entire issue is whether he skipped the steps. And the defense is arguing the steps don't matter.
But
He keeps
Judge,
saying he doesn't have to.
right.
Counsel, just because you say it doesn't make it true. What he does, what you're arguing to the court is that the officer, upon some assessment, can take some preemptive strike because he believes that something is going to happen that hasn't yet happened.
Well,
I'd like to see, is there
Even the-
case law that gets me
their
there?
policies and procedures provide for that. They can use the level of force that they believe is necessary. It's left to the employee's discretion. And it's enumerated in there. There's active resistance, passive resistance. If an individual is combative physically, or if they're just refusing to comply. Now, in this case, you're saying that he should have said, hey,
Just because you say it doesn't make it true. That's the judge naming the move. The defense wants this to be discretion. An officer makes a split-second call, but Simpson reframes it exactly right. You're telling me a man can launch a preemptive strike on a person in handcuffs because of something he thinks might happen that hasn't happened yet. That's not split-second life or death. That's punishing someone for what they haven't done. And he says it without raising his voice.
Okay, but the thing is, that would mean that anybody who is in the back of the vehicle an officer would be correct, or at least could properly, anybody coming in, whether they're screaming, yelling, doing anything, if they're in the back in all kinds of restraints, I can spray them or do something to them under the notion that something might happen when I open the door.
I think that that may be correct. However, in this situation, he's charged with specific crimes. There are other crimes that they can be charged with theoretically that wouldn't be assault with a dangerous weapon, i.e. a weapon that could cause serious physical injury or death. That would be a simple assault and battery. And an individual can be charged with assault and battery without being charged with misconduct in office, because while it may rise to the level of an A and B, it doesn't rise to the level of depravity, perversion, or corrupt intent. There's levels to this. The reason we're here is this is a felony charge in which they have to have probable cause for the charges they issued. That doesn't mean that another charge may not be more appropriate. These charges are not appropriate. And that's what we're here on today. And yes, officers are given great latitude to do their job. That is the law. Graham v. Connor, 2020 hindsight is not the standard. Can't second guess what he did. In fact, the court says unless the use of force is arbitrary, the officer has discretion. This is reading from People v. Sure. The officer has discretion within reasonable limits to determine the amount of force which the circumstances require. And he's not guilty of wrong unless he arbitrarily.
And he follows it all the way down the road. If your rule is right, then anybody brought in screaming, fully restrained, can be sprayed on the theory that something might happen when the door opens. He even concedes the defense might be technically correct on one charge. Maybe it's a simple assault, not a felony dangerous weapon case. He's not pretending the law is simpler than it is. He's drawing the line between I disagree with how you did your job and this crossed into a crime. That distinction is the entire case.
If the court would determine that a reasonable fact finder could conclude that it was an abuse of their discretion, does that then give rise to the potential?
I would say no, because then you're basing the decision to bind him over on the policies and procedures and not the action. See, this is the dilemma that we talked about. Yeah.
That's not true. What you're saying is that the discretion of it's really the discretion of the officer. That's what the policy is. I'm saying if one were to determine that it's an abuse of discretion, that equates to that depravity that we're talking about, or some corruption because it's an abuse of discretion.
No, that would mean
that be for the fact finder to determine.
I think you're mixing, in my opinion, Your Honor, I think you're mixing two different concepts together to get.
No, I think you are in trying to run me in a circle, because what I'm saying is if I take the policy,
correct,
and I take that policy and I say, yes, they have discretion,
correct,
but a reasonable fact finder could conclude that this is an abuse of discretion, which could be used as a factor to determine whether or not there's depravity or corrupt behavior.
Well, Your Honor,
then
I'll leave it.
Go ahead.
You to go.
And this is the cleanest piece of judging in the whole hearing. The defense's whole shield is the policy leaves it to the officer's discretion. And Simpson turns the key. Fine, it's discretion. But a reasonable jury could decide that spraying a handcuffed woman with no warning was an abuse of that discretion. An abuse of the power you were trusted with is exactly what corrupt intent is built to catch. When the lawyer says he's mixing concepts, the judge says no. You're trying to run me in a circle. He saw the move and stepped around it. So how'd it land? Simpson bound the sergeant over, meaning there was enough to send both felonies up to circuit court for trial. It didn't go the distance. Months later, he pleaded no contest to the misdemeanor. The 2 felonies were dismissed, and he got probation and a day in jail with credit for time served. You can have your own opinion on whether that's enough. But what I'll leave you with is the thing the judge was really protecting. The rule that you don't get to use force on someone who's already in handcuffs and already in your control just because they're difficult. That rule isn't there to protect the difficult. It's there to protect all of us. If there's a case or a courtroom moment you want us to break down, drop it in the comments. And if you want more of these, you already know. Like and subscribe.